Well, hello everyone, and welcome to this Innovate Finance webinar on UK data reforms and what they will mean for FinTech. My name is Rolf Merchant. I'm Head of Public Affairs at Innovate Finance, and I'm here just to kick things off and to introduce you to the Hogan Lovells team who will be presenting to you today. Hogan Lovells is, of course, a great partner of ours, and we're very lucky to have two senior lawyers to talk us through what is happening on data legislation and regulation here in the UK. So speaking today, we have Nicola Fulford, who's a partner in the Global Regulatory Practice, and Dan Whitehead, who is Senior Associate in the Global Regulatory Practice. I'll let them introduce themselves more fully in a moment. First, just to remind audience at home, Nicola and Dan will be pausing to take questions from you throughout. So if you do have questions, please do type them in on the little box there in the Zoom window, and hopefully we'll have time to address most, if not necessarily all of them. But I think that's it from me. So let me hand over to our speakers. Nicola and Dan, over to you.
Thanks very much, Rolf. And we are delighted to be here today with the Innovate Finance membership today. As Rolf said, I'm a partner in the Privacy and Cybersecurity team within Global Regulatory at Hogan Lovells, working on all aspects of data protection, helping clients come up with creative solutions for the use of personal data in a compliant way. Both Dan and I also work on data breach response and preparation. And in the FinTech context, we've done a lot of work advising on online banking transparency, customer authentication, use of cookies, processing data about vulnerable customers, DPIAs for online advertising, and the use of AI for those entities. We've also looked at kind of GDPR compliance uplifts for smaller fintechs in the context of their next investment round. Dan.
Thanks, Nicola. So yeah, I'm a senior associate in the Privacy and Cybersecurity team at Hogan Lovells as well. I have originally a technical background, having studied computer science, so I'm particularly interested in how the law and regulation interacts with how to comply in practice by building technical solutions. So my areas of focus, as Nicola's already alluded to, include cybersecurity, artificial intelligence, and the regulation of AI particularly, but also general data protection law and the reforms that the UK is proposing here is something we're already advising various clients on.
Ileana, are you able to put the slides up? So we've come up with some slides today to talk through these two major consultations for changes to UK data protection law and compliance. If we can go to the next slide, please. That's us. If we can go to the next slide and the next one. So the first section, we're going to be talking about the Ico consultation on international data transfers. Now, I know we have a bit of a mixture in the audience today. So some of you are perhaps lawyers who are advising on data protection, or privacy officers or compliance officers looking at this kind of area all the time. And so I'm sure you'll be super familiar with some of these points. Some others in the audience are of a sort of less legal technical background. So we'll try and strike a bit of a balance between the technical law, of which unfortunately there is some, and also what the implications might be for your businesses. Then after we looked at the specific ICO consultation on international data transfers, we're going to then take a look at the DCMS proposals for changes to the UK GDPR as a whole, and Dan's going to be sort of taking some of the key examples from that consultation. And then, as Rolf said, we're happy to take any questions as we go, and so do feel free to jump in with any questions, and we can address those as we go. And then finally, we've got some just comments on timings and next steps. So for the ICO international data transfers part, as a bit of background, the GDPR General Data Protection Regulation sets out restrictions on international transfers in Chapter 5, and that says that you need something in place where you're going to be exporting personal data from the UK or the EU. Sorry, if we can just go back one. To other countries. And then following that, last year, there was a decision in the case called Schrems 2, which said that some of the existing mechanisms to enable data transfers, in particular the US Privacy Shield, was no longer valid. It also said that the then current EU standard contractual clauses, which were used in both UK and the EU, can be used, but with an additional consideration of the specific risks of the transfer. Obviously, since GDPR in 2018, the UK has left the EU. The UK itself has been determined to be adequate. So you can freely transfer data between the UK and the EU, at least for the next 4 years. And then earlier this summer, the EU, following the Schrems decision, has put in place new EU standard contractual clauses to enable the export of data. And these take a slightly different approach to the previous clauses, and they have a modular approach. So there's 4 different modules that you can use. Next slide, please. So looking then at the specific ICO consultation, the ICO is slightly behind on the EU in terms of timings, because the new EU clauses have already been approved, and they, for new agreements, have to be put in place from the end of September, so already, and then there's a window for compliance for existing arrangements whereby you have to move over to their new clauses. The ICO's consultation is split into sort of 3 main sections. So the first one, they're asking questions about the applicability of some of the extra territorial aspects and transfers in that context. They've put forward a guidance on the transfer risk assessment and a tool that can be used for the sort of Schrems 2 decision part. They've put forward their own version of the EU standard contractual clauses called the International Data Transfer Agreement. And then finally, there's an addendum to be used with the EU SCCs. Can we go to the next slide, please? So firstly, in terms of guidance, there have been some questions, and there's some very detailed guidance from the European Data Protection Board on how the GDPR applies. So it applies to UK controllers and processors under Article 3.1. It also applies to entities which are outside of the EU, or in the UK GDPR case, who are sort of offering services to or monitoring data subjects within the EU or the UK. So the ICO have asked some questions about how that law should be interpreted, and whether if you have a processor who is always, of a UK controller, if they're always going to be covered by virtue of the GDPR itself, and under Article 3.1 or Article 3.2. Now, I'm not planning to go into all of the detailed ins and outs here, because it's quite a complex question, and it's only really going to be of interest if you've actually kind of had a thought and looked at that. But the UK ICO is considering changing some of those interpretations and saying, in some circumstances where we have all been using standard contractual clauses, they may no longer be needed. And in terms of the response to the consultation, there are some different thoughts, and I don't know if you within your own organizations have looked at these questions or considered these, but there are different options, and I think some of the feedback we've had when from talking to clients or thinking about this ourselves is, if if the GDPR had been intended to kind of cover everybody, everywhere, all of the time, then perhaps it wouldn't have been restricted in the way. And so we'd be inclined not to extend some of the extraterritorial effects of GDPR and therefore the impact on whether or not you need to use mechanisms such as the clauses. But
Nicola,
yes.
just to flag, we've received a question in relation to this. So the question is, I'm not sure how the ICO is planning to address the effects of Schrems 2 on the SCCs. Okay,
thanks, Dan. Could we just jump to the next slide, please, Eliana? So Schrems 2 did say that we needed to, you need to do a risk assessment of the specific transfers. And there's quite detailed guidance that the ICO sets out in this part of the consultation. And it sort of sets out 3 main steps that controllers need to consider when doing your international data transfers assessments. So firstly, it's around considering the facts of the transfer, which is, what's the types of data, what's the purposes, and sort of questions around the methods of the transfer. Would you have remote access, for example, in where data is hosted, perhaps still in the UK, but it could be accessed for support purposes for overseas. So those are the kind of factual element. And then it sort of sets out some questions to be considered around, the destination country, and making an assessment of the laws there. Now it's really difficult for particularly SMEs to sort of start to assess that. So I think in terms of feedback to the ICO, it would be good if they could do some more, here's a list of questions of countries which we think are low risk, but they do set out factors around how you could help with that analysis, and the sorts of things that you'd need to be looking at when you're carrying out that assessment. And then finally, as part of your impact assessment, you need to consider the potential impact on harm on the individuals. And if it's, just business contact emails, for example, and it's being processed by, you've got lots of security in place, then, you might sort of come to the assessment that that was okay. There may be other situations where you need to sort of perhaps put in place some additional steps if it's sensitive data, perhaps around your criminal background checks that or not criminal, but when you're doing your KYC checks and AML checks, you could pick up some sensitive data, and so maybe you may want to look a little harder at some of those transfers or vendors when you're considering your international transfers. I don't know if any of the audience have looked at the tool. From an SME perspective, it seems quite, it's quite long, it's quite dense. There's a lot to think about when you're looking at those impact assessments, but it's really helpful that they do set out the factors that you would need to consider, and they have sort of sort of decision trees, which might be helpful if they were part of an online tool eventually, and they also have some sort of tables of supplementary measures that you could take. So overall, we think that this is quite a good idea to have a draft tool, and it's presented in quite plain English, which is quite useful. But yes, I think there could be a bit more guidance, particularly on the laws of some of those countries. I see we've had another question on this tool, which says, does the ICO accept a risk-based assessment? For example, for the US, although there are rules that may allow the government to access EU data from cloud providers, it's very unlikely in most cases. Yes, it does broadly. It does. It does allow a risk-based assessment, and the Schrems 2 decision itself allows you to make an assessment and to come to a view. And I think that's the sort of thing that you would need to document. Is the kind of data that you're processing going to be of interest to US law enforcement? Depending on who is the recipient of your data, how many requests for data do they get? In fact, those are the sorts of factors that you would put in. But yes, both the ICO and the Schrems decision itself do allow for a risk-based approach.
So, Nicola, I just respond to the next question we got in,
sure.
which is
Thanks, Dan.
from Jerry. So Joey's asked, is there anyone at the governmental level that is monitoring the challenge of meeting these guidelines, along with the new TFA travel rules suggested guidelines? And I think the answer is yes. So we'll come on to this a little bit more in the next section, but DCMS within the UK government, as part of their proposals for reforming data protection law, include quite a comprehensive set of suggestions around international data transfers. Now, amongst those measures, their proposals include simplifying the existing safeguards for transfers to third countries, but they don't go into, at the moment at least, a great deal of detail about how they may simplify the risk assessment aspects that derives from Schrems too. So I think there's, as part of the wider consultation exercise that's currently open, and I'll explain more soon, an opportunity to push for greater clarity in this area. And I think just to further Nicola's point, while the ICO is clearly making an attempt here to, I guess, almost operationalize the risk assessment process that's been instigated by the EU authorities, and particularly the European Data Protection Board in their guidance, it's too dense and too complicated right now. And it'd be, except for the most sophisticated of organizations, incredibly difficult to implement in practice. And I think that's the practical challenge that most organizations have in reality. So yes. Hopefully that answers your question.
Thanks, Dan. Yes, I mean, it's a tough balance to take, because that complex risk assessment is required by the law, but yes, how does one individual small company go about doing that in a comprehensive way? It's very difficult to see. Ileana, if we could just, I'm conscious that we sort of jumped forward quite quick. If you just go back one slide. I just wanted to sort of say for completeness, some of the other questions on the sort of guidance look about whether you'd need agreements in place for overseas branches. And I think quite an important point is to say, if you have a UK processor for overseas controllers, would that mean that you're sort of widening the scope of GDPR? And in terms of responses to those consultations, we think it absolutely doesn't make sense that, and it wasn't the intention of GDPR to kind of give additional rights to data subjects who never had them in the first place, and it could reduce the competitiveness of UK processors if by the use of that processor, an overseas controller was suddenly subject to GDPR. So that might be something that would be useful to feedback on if the audience thinks that that's appropriate. If we can then go forward a slide, please, and then go forward again. So the next sort of section of the consultation is actually setting out the draft international data transfer agreement itself. And this, the structure is set out on the slide there, but it looks quite different if you're familiar with the EU standard contractual clauses. And in a sense, the order's kind of been reversed. So it starts with tables of information about the parties, other agreements, the types of data. It then considers any additional technical or organizational or contractual measures you might put in place following carrying out of your transfer impact assessment, as we were just discussing. Then it has, if there's an additional commercial clauses, you might want to cover topics such as liability or payment for some of the additional support that you're getting. And then similar to the EU standard contractual clauses, you've got the mandatory clauses. And in the same way that we're used to, these basically need to be used as they are in full without changes. Unlike the new EU SCCs, it's not modular. So it's kind of everything in one document, whether it's going from processor to controller or controller to controller, you know, all of the terms are in. It does set out some instruction and guidance, but we think it could be clearer as to what's sort of guidance. And I think they have attempted to make this sort of plain English for non-lawyers, but, you know, and maybe this is our inherent bias coming out as lawyers, ultimately, you know, bearing in mind that if there is a dispute between the parties, this could end up in court, you know, not using traditional legal language and replacing it with terms such as, you know, promise, or having terms which talk in general terms without, you know, an obligation on one party or other to do something. And there are those as well. You know, that may not be so good from a legal certainty point of view, albeit it may be more understandable to the non-lawyer. So in terms of feedback, that's something worth considering. The document itself is also very long. And I don't know, for those in-house people, I mean, we're always being asked, oh, this is huge. You know, we can't add a sort of, you know, in the old days, a sort of, you know, 15, 20 page supplement to a, you know, 5 or 10 page agreement. This IDTA is even longer. So again, just the sort of sheer volume, I think, is going to be off-putting. And I think that will make it challenging for particularly the SMEs or for some of your contract counterparties. One other point that you might want to consider on the IDTA is around, you know, there's a suggestion about making it this multi-party. And again, that may be useful for some of your arrangements. I've just seen there's another question.
I think the question from Leonard about blockchain and multiplayer games, it's quite a complex question. I think it might be beyond the scope of this call, but my very brief response would be, if it's a genuinely multiplayer game with individual users, and it's entirely peer-to-peer, so there's no central party that's running the application, then it's entirely possible, at least from a GDPR perspective, that it wouldn't even apply, because there's what's called the household exemption, which allows where you're processing personal data for household use, so in your own personal capacity, then you may not be considered a controller or a processor for that purpose. And that's a really simplistic answer to your question. But if the GDPR was to apply and other data protection laws, then blockchain does create inherent complexities, ones that are not easily solvable. And I think it's an area that data protection law could be reformed to consider the implications of blockchain.
Yes, and blockchain was also something that Hogan Lovells has published, you know, quite a bit of guidance on as well. So do get in touch if that's a topic that you're interested in, but we don't have time to go into detail here because it's not relevant to the consultations. But thank you for the question. Moving on to the next slide, please, Ileana. So the final part of the consultation is what's called an addendum to the EU SCCs. And this allows you to use the EU SCCs instead of the UK IDTA, but it basically has provisions within it that allows the EU SCCs to work in a UK context. So, for example, it might change, you know, member state supervisory authority to ICO, for example. And it can be used for both data transfers from the EU and the UK. And also, we understand, although it's not explicit, and we'd suggest it be more explicit, it can be used for data transfers from only the UK. But given a lot of organisations operating in an international way will also have to use the EU SCCs, this seems, you know, broadly a really good idea to enable the use of the EU SCCs. So, you know, we'd suggest you may want to be supportive of this proposal to have an addendum, and the addendum itself is quite short and straightforward. So, you know, in terms of feedback, we think it might be explicit that we could, that the exact format of the addendum wouldn't have to be used, but you could perhaps, use that within your wider data processing agreement. But that's something in terms of the feedback that does seem to be a good idea, rather than having to use both the EU SCCs and the UK IDTA, where you have transfers from both. Conscious of time, so Dan, could we advance the slides again, please?
Yeah, do we want to pick up on that before I move on to this section? There was one final question that we received. And it says, is it clear if the UK SCCs can be used not only for the transfer of UK data to a third party country, and also, I think the intention is, but also for the data back from the third party country to the UK?
So if, for example, you had a data transfer from, I don't know, say, would you, the US to the UK? I'm guessing that's what the question is getting at. If it was just a transfer, kind of an import of data, in that context, you wouldn't need to use the UK SCCs, because there's not that restriction. However, I guess there could be a context of perhaps, I don't know, a European country, or other a US-based controller who was subject to GDPR, and there are some questions around that applicability in the guidance section. The other point that's worth noting is, in the guidance, they also ask about whether, in terms of the addendum for the EU clauses, so whether it should be extended for other countries. And so, for example, there's a similar thing to the UK addendum around Swiss law, but we think it would be useful, for example, when the new Chinese personal information protection law comes into force, I think in November. There will also be clauses for the export of Chinese data. And so if it could be made compatible with the Chinese clauses, that also seems to be a good idea. And any additional clarity that widens the use of these documents, I think, would be helpful. Moving on then onto the proposals for wider data protection law reform. And again, happy to take anything in writing later.
So I'm conscious that there were quite a lot of questions just on international data transfers, and I expect there may be many more in respect of this. So to distill it in simple terms, as I mentioned before, Dcms within the UK government has issued a very detailed paper which sets out a set of proposed reforms to UK data protection law, which is inherently based on currently EU law. Could you go to the next slide, please? And essentially, this is part of a wider government process where they're seeking to reform EU laws and review whether they could be made more business friendly. Two of the objectives that are referred to in the paper are reducing box ticking exercises, but also encouraging innovation by potentially making tweaks around the edges of data protection law where there may be problems at the moment in being able to use data for certain purposes due to the requirements that are imposed under the GDPR or PECA or the UK Data Protection Act. The proposals are very much not finalised, and they're currently subject to a public consultation that opened last month. And the consultation is essentially integrated within this detailed paper, which is over 140 pages long, with a number of questions in relation to each of the areas where the UK government has proposed changes, asking organisations essentially, are we heading in the right direction? And if not, then what else do you suggest? So I think one of the key messages from this, because we're not going to have time to go into the full details of all these proposals, is that the UK government is open to suggestions for how data protection law could be reformed, particularly if they are pragmatic and sensible suggestions that aren't going to significantly compromise the rights of individuals and their privacy. So it's worth taking into account what they're suggesting at the moment, which I will come on to in a moment, but also what else they may be missing. And there's a real opportunity there during this consultation period until November to make these proposals in writing, and then it will move on to the next stage, which may be legislative reform. Could you go to the next slide, please? I'm going to go through, because there are so many proposals, we tried to group them into 4 buckets and just cover the ones that are perhaps the most interesting, but there's a load of others that may also be relevant. And I think those buckets are essentially trying to encourage greater innovation of UK companies, artificial intelligence, accountability, so privacy governance essentially, and then there's a few other kind of odds and ends that we've picked up on that are also worth mentioning around regulatory reform. So to begin with, in relation to encouraging innovation, the few of the proposals here relate to, for instance, the relaxation of restrictions on scientific research. So scientific research is referred to at various points in the UK GDPR at the moment, but the concept of what is scientific research and to what extent does it cover commercial research, for instance, and in what circumstances, isn't that clear. So what the government is proposing is to essentially define what the scope and boundaries of scientific research are, which we would expect include also software development, etc., and technology, other forms of technology. In addition to that, they are also proposing the integration of a new lawful ground for processing into the UK GDPR that's specific to scientific research. So in other words, instead of having to find a lawful ground for processing such as consent or legitimate interests or performance of the contract, if you're using data on a secondary basis, for instance, relating to your customers for the purpose of research and development, such as improving your products, using it in training data for artificial intelligence models, then the government is at least indicating they're open to introducing a new lawful ground which would permit that type of processing. And that also extends to certain proposals around special category data as well, and the additional conditions that apply there. The second proposal on that slide is relating to legitimate interests in itself. And for those of you who are familiar with data protection law, legitimate interests is often the default ground that organizations rely on when they're seeking to use data for a variety of purposes that don't fit neatly into being necessary for the customer's contractual relationship, and you don't want to obtain consent. So one of the issues the government, though, has, I think, rightly identified is that legitimate interest is a difficult condition to satisfy in many circumstances and understand when you can satisfy it because of the balancing test that applies as part of that ground. So they're essentially saying legitimate interest will stay and the balancing test will stay, but there will be certain exempted processing activities where they'll be listed there in legislation, and they will say, for these processing activities, you do not need to undertake a balancing test. By default, they are inherently considered to be lawful under the legitimate interest ground, which is quite an interesting approach, and I think has the potential to reduce some of the compliance burden associated with trying to understand what is permitted and what isn't under this ground for processing. The third proposal there is defining the test for anonymization. So many clients, particularly those who are looking to use data for aggregated purposes and data analysis, will often ask us or say we're anonymizing data, and then unfortunately the response that we often give back is, well, are you anonymizing data really, given the high standard that's set out under the GDPR? Is it potentially pseudonymized data instead, which is subject to data protection law still? And what the government is essentially proposing is that they will clarify the extent to which, or the circumstances where you can say data is truly anonymized under data protection law and therefore not subject to the GDPR's principles. So I think that's an important development and one that they should take forward. And then finally on this slide, the relaxation of cookie consent rules. And some of you who may have been paying attention to the news, this is probably the proposal that got the most attention when the publication was announced last month. And I think there was some headlines around ditching cookie consent banners for good and reform of cookie requirements. And I think that's slightly misleading. I'm not sure that's exactly what the government is proposing here. There is a reference to the possibility of moving away from cookie consent banners, and I think that could be a positive development in the future. But there's also an acknowledgement that there needs to be an alternative means by which users can exert their preferences in relation to what cookies and similar tracking technologies are installed on their devices. And I think the government's proposal there is that there needs to be better international cooperation, but also there needs to be functionality provided through online browsers and other mobile devices, which allows better control of cookies in practice before the awful scourge of banners can be removed for good. But one interesting proposal that I think is more concrete is permitting certain forms of analytics cookies to be installed without consent. So in other words, the current rules regarding strictly necessary cookies where you don't need to obtain consent will be expanded to cover a wider set of purposes, including analytics where it's not around user profiling. Next slide, please. So separate to the innovation proposals, or I guess part of the innovation proposals, is a very dedicated section on artificial intelligence, which is a key part of what the government is seeking to focus on, both from encouraging innovation, but also regulating the sector, or the technology, perhaps more accurately, in the future. They've, separate to this proposal, issued a national AI strategy only last week, in fact, or 2 weeks ago, which includes a suggestion that they will, for the first time, acknowledge the need for cross-sector government regulation of AI, which it's unclear what that might look like, but could certainly make use of similar principles that are outlined in the EU's own AI regulation, which was announced earlier this year. Focusing on the DCMS proposals we're looking at here, though, there are a few specific areas where they're making proposals, and one of them is an interesting concept of extending the principle of fairness under the GDPR, which applies to the processing of personal data, to not only cover the processing of the data itself, but also the outcomes from AI systems. So in other words, the outputs and decisions made about individuals, and potentially making it explicit that organizations have to ensure fair outcomes from the AI models, not only fairness of the underlying processing of data in connection with those models. And in practice, what that means is that there may be a statutory basis for requiring organizations to, for instance, remove algorithmic bias and ensure a certain degree of statistical accuracy in models going forward. So they're consulting on that suggestion, whether that should be part of the GDPR explicitly, or possibly part of a separate dedicated AI law instead. They're also discussing reforming the automated decision-making obligations, which are set out in Article 22 of the GDPR and apply to solely automated decision-making. For those of you who are familiar with that obligation, it can be sometimes unclear whether it applies, because it doesn't apply to all automated decision-making systems. And the government's essentially saying, we will review the relevance of this existing obligation, and whether it should either be removed entirely or possibly expanded to include a broader set of automated decision-making obligations. So they're kind of caveating their position there, and they've set out a number of conflicting proposals, I think, to understand what the pros and cons are of this obligation as it stands and whether it should be reformed. The third point on the list is around greater freedom to use personal data. And this is linked to, I think, a broader emphasis on ensuring fairness in AI, and particularly with respect to concerns around algorithmic bias. So what the government's saying is, we want to encourage organizations to take technical steps to ensure that their AI models and similar systems perform in a way that removes or at least mitigates the risk of algorithmic bias. And because organizations have rightly pointed out that that can be quite difficult in practice due to the lack of a lawful basis under the GDPR to process data for those purposes, they're saying we will explicitly permit training and testing, the use of personal data for training and testing purposes, including, interestingly, special category data such as people's ethnicity, etc., which is important in being able to understand, for instance, whether a model is biased against a particular ethnic group, by way of example. Next slide, please. So moving away from innovation and AI, accountability is obviously a core component of the GDPR at the moment. And it is one of the big changes that the GDPR enacted based on previous data protection law. And essentially what it means is that organizations are explicitly required to demonstrate how they comply with law, the data protection law in practice. The UK's DCMS proposals are making a number of quite significant reforms to that or the subsidiary obligations that fall under the umbrella of accountability. And that includes potentially proposing the complete removal of the obligations to undertake data protection impact assessments, to maintain records of processing, and to appoint a data protection officer. That doesn't mean that they're just kind of brushing away the need for accountability. But what they're saying instead is that, and you can agree or disagree with this, it's to checkboxy the current situation under the GDPR. Organizations are not taking privacy seriously, and they should have greater freedom to determine how they go about ensuring that they comply with data protection law in practice, as opposed to it being a very discrete set of activities that need to be performed. So they're introducing or proposing to introduce this broader privacy management program obligation where you have to have a governance system in place, with the emphasis being on organizations to determine what that looks like, taking into account the size of the organization, sophistication, and how they're using personal data. So if you're an organization that has very limited use of personal data, which I imagine doesn't apply to many of the attendees on this webinar, then you may not need to be too concerned with privacy governance. Whereas if you're using data in several sophisticated and potentially harmful ways to consumers, then there's a need to build a comprehensive privacy program. So I think this is probably the biggest example under the proposals where there may actually be more barriers introduced under the GDPR for compliance than currently exist, and it's worth noting. The other couple of
just jumping in, we've just had a point from the audience saying, you know, the elephant in the room is that if taken forward as currently set out, you know, does this kind of removal of some of the protections under UK GDPR mean that our EU data adequacy from the UK is unlikely to be maintained? And the questioner says, whilst I appreciate you can't tell for sure, do you agree this will pose a significant challenge to data adequacy with the EU? I mean, from my point of view, maybe while you're thinking about that, I think these are proposals, and they do kind of, there is a sort of strong sort of underlying thread that, you know, the intention is to make this a bit more kind of streamlined, less box ticking, but to still, you know, protect data subject rights. So I think it very much depends, you know, how the consultation goes, what the resulting, you know, law turns out to look like. But yes, there could be an impact for our adequacy. And also, I think it's worth noting that the UK's adequacy is only fixed for 4 years, which is very different to literally every other adequacy decision, which, whilst they are subject to review, they don't have a sort of, you know, a built-in requirement to review them within a time period, and they end at that point. So, you know, I think the UK, you know, would have to mean it in terms of protecting privacy rights and looking at alternative means, because other adequate countries don't, you know, have all of these accountability laws. So that in itself does not mean, you know, because you don't have a DPO, you can't be adequate, but do you still take privacy seriously? And I think, you know, time will tell how this plays out. Dan, I don't know if you have any other views, or if you just want to move on.
No, I totally agree with that. I think I think there's risks relating to the proposals. I think one of them particularly, which I don't really focus on in this talk, but is interesting, is the potential opening up of adequacy decisions, particularly if, for instance, so sorry, to provide context, what the DCMS paper suggests is that the government may relax the standards that apply to them granting adequacy to other third countries, such as maybe the United States, for instance. So they may seek to agree some kind of adequacy package or a privacy shield equivalent with the US as an example, and then permit free transfers of data from the US to the UK through that mechanism. And I think one of the discussions we've had internally is whether that type of relaxation could provide ultimately, if you think about it, a way of avoiding US concerns at an EU level and contravening or circumventing, perhaps more accurately, the transfer obligations in the EU. And the way that might happen is if the US entity was to transfer data freely to the UK, and then a UK entity was to transfer that data to the EU under the adequacy arrangement, meaning that there is at no point the safeguards in place that the EU is expecting. So that's an interesting, I think, perspective.
Yes, I think those onward transfers, it is a concern.
Just moving on, so a couple of other points on this. So one of the issues that I think is not an unreasonable one to point out is that the ICO currently gets inundated with data breach notifications. And one of the themes of the paper is that the government wants to move the strategic direction of the ICO to focus on significant material infringements of privacy law and away from dealing with day-to-day large volume notifications and complaints that take up all of their resources without enough time to focus on the big picture. So as part of those proposals, they're saying we want to increase, not significantly, but marginally, the threshold for reporting data breaches to us or to the ICO. So at the moment, the obligation is invoked unless the organization, the controller, assesses that it's unlikely that the breach causes a risk to data subjects, which often results in, I'd say, quite frequent reporting because it's a relatively low threshold, a risk as opposed to a certain level of risk. So the proposal is to add a materiality element to that, essentially, which they think could result in fewer reports and also less bureaucracy for organizations. And then finally on this slide, the data subject access request reforms are quite specific and tailored. So they're saying there's too many DSAR requests being made. Many of them are vexatious, and therefore there should be some restrictions such as what were in place prior to the GDPR to limit the extent to which individuals who have genuine complaints unconnected to privacy can use DSARs as a way of circumventing, for instance, the disclosure process. So they're proposing the reintroduction of some kind of data subject access request fee that may have to be paid, but also interestingly, maybe a cap on costs that organizations have to incur in complying with a request. So this is already a system that's in place under the freedom of information laws in the UK, where public authorities only have to spend a certain amount on a request, and beyond that, they're not obliged to continue performing the request. And there's a suggestion that you could introduce a similar measure in the UK to limit the liability of organizations who are receiving large volumes of DSARs. Next slide, please. So finally, just to kind of point out a few other things that don't fall neatly into any of the previous buckets, I've mentioned that there are some proposals around international data transfers, which are quite detailed, and I'm not going to go into huge amounts of detail about them now. But one to point out is the interesting suggestion that despite all the work the ICO is currently doing on reforming the SCCs and introducing the new international data transfers agreements, the government, perhaps in a slightly uncoordinated fashion, is suggesting completely reforming that proposal and allowing organizations to determine themselves what safeguards may look like in practice. So in other words, rather than having to rely on a particular set of standard contractual clauses, an organization could self-certify themselves as providing sufficient safeguards in respect of a particular transfer through other means. Quite what that might look like and whether there'll be any guidance on what kind of safeguards organizations could initiate that aren't contained within the International Data Transfers Agreement is open to discussion. A couple of other points include and this is, I think, a significant one that's slightly buried in the proposals, increasing the fine levels under the privacy and electronic communication regulations from their current level, which is a maximum of £500,000 per infringement, to GDPR standards. And that would essentially mean that infringements relating to direct marketing, but also perhaps most importantly, cookies, could fall under the remit of GDPR level fines, whereas at the moment, those fines are arguably restricted to PECA levels, which are 500k. And there's also more limited powers that the ICO has in terms of other enforcement means and sanctions under PECA at the moment, which the government's suggesting should align with the GDPR. And that would reflect the approach taken in other jurisdictions, such as France, that already has GDPR level fines for cookie infringements, for instance. I've mentioned the kind of change in the strategic vision of the ICO, and linked to that is an interesting idea about resolving complaints. And again, in order to reduce the workload and volume of complaints the ICO is receiving, the government suggesting that data subjects who have a grievance should have to raise those and seek to resolve them with the underlying controller or processor prior to bringing them to the ICO's attention. So in other words, the ICO won't deal with your complaint unless you've sought to resolve it already with the organization. And that's ultimately going to potentially place less burden on the ICO, but also more burdens on organizations to resolve this outright prior to an ICO referral. And at the point of a referral, it may be taken more seriously because there'll be fewer complaints in total. And that covers kind of the big picture key reforms. There's 100 others, but I think we won't have time to cover those, but I think we'll open it up to questions.
Just while we're waiting for other questions, I think it's worth also pointing out that later this year, the current Information Commissioner is going to be leaving and a new Information Commissioner will be appointed. And also the sort of timing is that the kind of strategic goals and what have you of the ICO is kind of up for change anyway. So I think we will be seeing changes with the sort of change of personnel and leadership. So we might find that there will be changes at the ICO, sort of regardless of these proposals. So that's something for kind of fintechs on the call to be aware of, that there could be a change in focus already.
Could we actually just go to the next slide, please? There were a couple of other points just worth highlighting, that just to reiterate, like, this is a major opportunity for the fintech community to consider not only restraining yourselves to what is in this proposal, because I think the government has consulted to an extent, but also just coming up with their own ideas to some extent as well. But rather than just focusing on the actual proposals themselves, also thinking, what else is missing? What else is it that we find difficult to adhere to at the moment that could be relaxed or reformed? The actual consultation deadline for the DCMS proposals is the 19th of November, so there is a bit of time. And we are assisting with various organizations in preparing responses and considering the nature of those.
And I think in the sort of financial services kind of context, it's worth thinking about, there are, there's sort of the widening of the lawful basis. You've currently got specific conditions around things like, preventing fraud or, AML and what have you. Are those sufficient, or do are you struggling with those and you need to expand or have explicit within what's legitimate interest, some of those kind of public policy type reasons, along the lines of the sort of, the research as well. That's worth thinking about there. And Dan, I think there's another question here about the government's AI strategy. And it asks, do you think that on balance, the reforms will make AI development and use in fintech easier or more economically viable?
I think the AI strategy is sufficiently vague to interpret it in several ways. Like, there's a big focus on encouraging innovation and investment in AI, which I think will assist with the government's ultimate goal, which is, I think, to make the UK the world leading centre for AI. Whether that's in practice going to be achievable is another question, but that's certainly what they're presenting the strategy as. But reading between the lines, what the strategy is also saying, and as I referred to earlier, is that they do intend to introduce new cross-sector legislation in this area. So ultimately, this is going to inevitably involve additional compliance burdens, additional compliance requirements that you're going to have to comply with, and that may involve interventions in the way you develop and procure AI technologies. I think it's worth also referring to the fact that this is not just a UK specific problem, it's very much a growing issue across jurisdictions, or a growing trend across jurisdictions where a specific AI regulation is being introduced. I mentioned the EU earlier. The AI regulation there is very comprehensive and includes a significant number of quite onerous burdens on organizations regarding the development and governance of AI tools, particularly those that are considered high risk, which includes credit monitoring and type software.
Sorry, Dan.
Sorry.
No, carry on. No.
In addition to the EU perspective as well, there's also AI regulations and scrutiny being brought in China, the US, etc. So this isn't going to go away, and I think I'd very much view it as a GDPR style reform of AI. So the equivalent as what we just went through with personal data in 2018.
Yes, I'd agree with that. I think we're also seeing more of a focus, as you mentioned, across different jurisdictions, but on the sort of ethical side of the use of AI. And I think fintechs have, you've got quite a good story to tell in terms of the use of AI to, for example, identify vulnerable customers, or to prevent fraud or ID theft, or certain kind of push payment fraud, all of those kinds of things. It's worth, it's not just kind of AI is could be used in ways that are detrimental to your customers, but also they can be really protective of your customers. And I think it's it's worth the fintech community kind of making some of those points. Just in terms of timing, Dan mentioned the sort of there's plenty of time for, well, not plenty of time, and there's so many consultations at the moment, but there's DCMS wider data reforms. But if you did want to give any feedback and you haven't already done so in terms of the international transfers specifically, the deadline is actually tomorrow. So but I think some of the points could be made in quite a short email. If you go to the ICO's website, then you can just sort of drop them a quick line on that. There's a question come up sort of saying, in terms of time horizon, do we have a sense of how quickly data protection reforms are likely to progress, and do you have an educated guess as to how long firms may be given to implement them after they're finalized? So I think in terms of the international transfers piece, I would expect to see a version of the IDTA and the TIA tool. Probably, I think their intention is to put those forward to Parliament by the end of the year, and so probably early next year. But as I say, it's more limited. And there's it's building on very much on the existing law for those and compliance with the existing law. I think with the wider data protection reforms, I mean, it's a really interesting topic, but I would expect to see those timelines being considerably longer. And I think to the extent that there are significant changes with respect to compliance, I would expect to see probably we often get kind of a year or so to kind of implement. When we had the GDPR, we got the law quite some time before organizations, firms had to comply with that. So I think I would hope that it wouldn't be here's significant changes to how you're doing things, and you need to do things in 3 months, and even updating the kind of SCCs and getting all those signed is the exercise in itself.
Yeah.
Dan,
Just on particularly the legislative reforms, one thing that's striking from the paper is, as I mentioned, it's very detailed, but also it's written a bit like they're describing changes they've already considered making to the text of the GDPR. So in other words, it's not vague, it's very specific, and you could probably take a decent guess of how to edit the GDPR based on what they're proposing. Which does indicate to me that following the consultation, it may not be that long into the next year in which they propose a bill before Parliament to amend the UK GDPR. With respect to the international data transfers, I think there's also perhaps a point around implementation there. And I think the transfer impact assessments element, my guess would be that they'll expect you to be undertaking those already, and therefore there may not be a huge implementation period, given it's just a set of guidance around existing law. Yes. But with respect to the changes to the SCC from SCCs, or the old SCCs that the EU had in place, to the new IDTA, I imagine, I don't know what you think, Nicola, but I think it will be longer because there's a practical element of having to update your contracts, which takes time.
And the EU, for example, gave over a year for that, for new arrangements. Conscious that we've reached the end of the time and we've still kind of been getting in new questions. Can we just go to the next slide, please? Just to say, if there's an interest from Innovate Finance members, please do get in touch. We're very happy to do a follow-up session, or to kind of answer any questions. If you've got any specific questions that you would be interested in, please do get in touch, either with us. I think there's our email contact details on the screen now, and also Rolf and the Innovate Finance team, if you'd be interested in a follow-up or further considerations around any particular topics, please do let us know. Rolf, did you have any sort of closing comments?
Well, simply to say thank you very much indeed for running through that. It's a tremendous amount going on, and I think to have it broken down in the way you have is a great help. Absolutely echo what Nicola says about follow-up. I know a couple of people asked for the slides. I think we'll be sending that round as well. And yes, this is an issue that's going to run and run, so I'm sure we'll be revisiting it in some way, shape, or form, perhaps in person next time, who knows. But no, just to say thank you ever so much to Nicola and Dan for running us through that. It's a great help. Yeah, looking forward to following up on this and other related issues over the coming months. But that's it from me, so thank you.
Thanks very much then. Thank you. Bye for now.
Bye-bye.